Welcome everybody to this afternoon's talk, which is, as Emily says, the future of mediation, and it's been given as part of International Mediation Awareness Week 2020, which I'm delighted to be a part of. Shout out if you can't see the slides, or put it in the chat. My background is I'm a mediator and I'm a solicitor, and I've specialised in dispute resolution and been involved with it in various forms since probably the 1990s. And having been involved in lots of mediations, probably in the hundreds, I now specialise in property disputes and wills, probate and inheritance disputes. Why am I supporting International Mediation Awareness Week? Well, I think, like probably some of the people on this chat, I'm really passionate about mediation. It's a fantastic process. I've seen the benefits it can bring to people in conflict and the opportunities for better relationships in our business and family lives. And without getting too high and mighty, I think it's quite an ethical and responsible way of resolving disputes, because you can end up with a win-win, hopefully, rather than a win-lose or a lose-lose scenario. There's a lot of information available and access to resources for people about mediation and how it can help. And it's on lots of different websites if you know where to look, but it's hard to navigate. So we think, more needs to be done to tell the world about mediation, and this is where initiatives like International Mediation Awareness Week can, showcase mediation around the world and raise awareness. So what are we going to cover this afternoon? I think what we'll do is we'll have a quick review of mediation, what it is and how it works. Apologies to mediators, because I'm going to keep it very simple at that point. We'll then cover how did we get here, the mediation journey. We'll touch on remote mediation, what it is, why it's such a great tool, standards and training and where we are with that. We'll have a quick look at the Singapore Convention. It'll be a very quick look. And then we'll wrap up with, I suppose, my looking into a crystal ball as to what the future of mediation might be. So first of all, what is mediation? Well, in its basic form, it's a process in which two or more people involved in a dispute meet, and with the help of the mediator, who's a neutral third person, they work out a solution to their problems. And so you might ask, well, what stops people moving forward on their own? What we find is that in conflict, most people go into fight or flight mode. There's disagreement, misunderstanding, misapprehension, poor communication, or worse, it could have started to result in insults, and these have created a lack of trust. And often in that situation, you see everything which the other side does as being purely for cynical reasons, and you have a bias against them. So nothing is trusted, and the parties become entrenched, and you find reasons to perhaps to justify your position to win the argument. You might not want to lose face, and this might be important if you're part of an organisation or perhaps a family who also have an interest in the outcome. You might be representing them. And mediation can break that deadlock. So let's just call it, I suppose, a form of assisted negotiation with a neutral third party. It's not a legal process. You can have lawyers if you want. They're usually helpful if they're there, but you don't have to have them. Participants can confide in the mediator themselves and use the mediator to explore options and ways forward. And the mediator works with each person to help focus on relevant issues and identify workable solutions. And as you can imagine, this often involves untangling, rephrasing or repositioning the parties out of tricky sticking points. How is it conducted? How does it work? Well, it's very flexible, and that's the beauty of it. But traditionally, it would take place in person at a venue like an office or a hotel or a conference centre. And, it typically you'll go to a very fancy law firm with lots of rooms, and but it doesn't have to be like that at all. I've done them in those sorts of offices, but also in church halls. So it is really flexible. There's an increasing move, of course, towards remote mediation, which we'll touch on, online or telephone. And of course, during the pandemic, online mediation by Zoom has really taken off, and we'll come on to that. The time and the number of sessions required depends upon factors that you'd expect, such as the number of people involved and the type of issues and the complexity of those issues. And I suppose the willingness of everyone to be open and to act in good faith, and their wants and needs and what they want out of the dispute. Each mediation is different, but in most of them, the parties will start by describing the dispute from their point of view and in their own terms, and perhaps how they feel it could be resolved. The mediator listens and guides the parties, hopefully impartially, without judgment, and generates and explores possible solutions. It's confidential and, as lawyers say, without prejudice, so it's a safe space. The mediator won't disclose confidential information to the other party or anyone else without your permission. They're unbiased, and they're not there to give legal advice or to be a judge, court or tribunal. Of course, at the end of the process, what you actually want, if they reach agreement, is probably, in most cases, a legally binding settlement agreement. It's also consensual, meaning that while parties have to agree to enter into mediation for it to take place at all, they're not usually compelled to do so, although, again, we'll look at that later as well. So moving on to the mediation journey, and how did we get here? It's said that it's over 5,000 years old, and there's evidence that in ancient Greece, village elders used to mediate local disputes between the villagers. Informally, I guess. But our modern mediation methods have developed, I think, from about the 1970s onwards. And over the last few decades, we've seen the creation of organisations and bodies providing mediation services, panel membership, training. I looked to see when the phrase win-win was first used in this context, and my guess is that it was with Stephen Covey's book, 7 Habits of Highly Effective People, that a lot of people had to read because their boss told them to read it. But that came out in 1989, and that I think that was the first time the term win-win was used. In other words, you have a negotiation where both parties win, rather than one party winning and another losing, or both losing, which is so often the case with litigation. In my own experience, mediation began to be taken seriously in the legal world in the UK in the 1990s. In 2008, there was a European directive on encouraging certain aspects of mediation in civil and commercial matters. And in the UK, we now have 2 core quasi-regulatory bodies covering civil, commercial, workplace and family. That's the CMC and the FMC, and they oversee training and development and standards for their members. I think also it's fair to say around the world we're seeing an interest in mediation developing across businesses, education providers, community groups and more, and some people predict that it will be taught in schools and workplaces as a matter of course and as a way of avoiding and managing conflict, which I think would be pretty impressive if we could get to that stage. It's not yet compulsory though. In the UK, the court can make a costs order against you if you don't mediate, but they can rarely force you to mediate. There are moves towards making it compulsory in some cases before parties can go to court in the UK. So in family cases, I think you have to tick a box before you issue proceedings for financial relief to say you've gone to mediation. I think in construction disputes, it's built into the pre-action protocols and in the TCC guide. And the courts have made it very clear that they do not want to hear neighbour disputes because they think they should be routinely mediated rather than go to court, and they've been very clear about that. So where are we? We've come a long way, but we're not regulated, and mediators don't have to have a license to practice. So remote mediation, it'll be interesting to see if we in the chat afterwards who's conducted a remote mediation perhaps during COVID, and we could share our experiences. But basically, what is it? Well, it's not difficult to see that it's mediation conducted online or by telephone. How does it work? By the most part, I think at the moment via Zoom. I think most people are using Zoom because it's got the breakout rooms. I don't know of anyone using Teams or Skype. I haven't used those just because Zoom's so easy to use. The breakout rooms create the private areas to preserve the confidentiality for the private sessions with the mediator, and then bring parties together for the joint meetings where you need that. So why is it so important? What are the advantages? Well, the obvious advantage at the moment is you can avoid travel and the risk of getting and spreading COVID. You can have your mediation in your home environment. So this could be a real advantage to you. It can be a lot less stressful than having to travel into a big city and attend some lawyers' offices with lots of people. I think this is a real advantage for perhaps for introverts, people who much prefer this way of dealing with things, particularly where there's emotional issues involved. Great for people with childcare issues or people with mobility issues. It saves time, it removes the venue costs altogether and removes your travel costs. Also, I found that with online mediation, you can take a flexible approach, so you don't have to have your mediation session starting at 9 o'clock and finishing at 6. You can break it down into manageable chunks over the day or over 2 or 3 days or perhaps a week. And that's a real advantage because you can have a break and you can reflect on things. And in any event, I think more than 3 hours is quite difficult being on a screen. So it's nice to have those breaks. It's also an advantage for where you've got parties in different time zones, because you can schedule the mediation to suit everybody or stagger it over different time zones. Is it here to stay? Well, I think it is. I'm going to read you an article from law.com, which appeared a few days ago. That's an American legal website, and it was an article from a participant in a corporate mediation, so a dispute about corporate. It was a shareholder dispute, and he said, I recently participated from home in an 18.5-hour Zoom mediation with more than 35 parties and their counsel attending. Wow. The mediation started on a Friday at 9 AM and ended successfully Saturday at 3:20 AM. One benefit to holding the Zoom mediation, he says, defence counsel together in a breakout room watching on a shared screen the final minutes of the Heat's victory over the Lakers in Game 5 of the NBA Finals. Another benefit to ending the Zoom mediation at 3:20, he says, no packing up and driving home. I was in bed 10 minutes later at 3:30 AM. So, you know, business people like it as well. I don't think that's going to go away. With online mediation, there are concerns that have been expressed about the reduced human interaction and not being able to read the subtleties of body language and non-verbal communication. The other concern is the confidentiality aspect and the control of the environment of the parties. When you are all in a room together or in 2 or 3 rooms, you can control who's there, you can see who's there. With mediation on Zoom, you don't always know who's in the room. I had a neighbour dispute recently where there was a lot of paranoia and distrust on one side, and there was a good reason for that, and that party explained it to the other party and it seemed really reasonable. So I was with another mediator and we said to the the parties receiving the explanation, well, that must be all right, that must have satisfied you, we can just get on and settle it. And what we didn't know, because we couldn't read the body language, was that none of this explanation was accepted. It was just simply wasn't trusted or believed. And there was nothing over Zoom that gave us that indication. So we had to carry on working with that party so that some trust was developed. And that was a definite disadvantage. It didn't stop it settling successfully, but we just had to work a bit harder. I think tweaks to the approach and to how mediation is prepared and documentation hopefully will reduce those sorts of risks. We'll hopefully see e-signatures becoming more common, so a settlement agreement can be finalised quickly and easily online. So where are we with standards and training? Regionally, research shows that standard mediation course is broadly similar across regions worldwide. Some countries sort of have a little bit more kudos as being or having leading providers of mediation training. However, it's currently about a week's training course to be a mediator wherever you are. No prior qualifications needed, of course. And different sectors have different approaches. So in family law, they have a very supportive approach for newly qualified mediators, including supervision and reflective learning. But I suppose in civil and commercial and workplace, there's no framework really to support mediators in their first few years. And different providers set out criteria to meet to join their club, but there's no collective approach to that really. Globally, we have the International Mediation Institute and the Chartered Institute of Arbitrators and other providers that have a global presence. But it seems that more needs to be done to harmonise this so that we hopefully have a clear global approach to training and development and support for mediators. The current approach when you complete the training course is that you either pass or fail, and there's nothing to distinguish between different practitioners, for example. It's fair to say that really with the training, the emphasis appears to be on the establishment doing the training rather than the training itself, rather than the substance of the training. The Singapore Convention, this is being covered in other talks, so it's not a detailed analysis. And this isn't, Jonathan Lux is talking about this on Thursday, so I'm just going to touch on it. What is it? Well, historically, a drawback to the use of mediation internationally was the lack of any harmonised framework for cross-border enforcement. So you might have settled a case, but you had to go and enforce your settlement agreement in another country, perhaps because the other side you were expecting to pay you lots of money didn't. So it's in response to this that the Singapore Convention was developed and adopted by the UN. And the primary goals of it are to facilitate international trade, to promote the use of mediation for cross-border commercial disputes. Essentially, what it does is it allows courts of signatory countries to enforce settlement agreements entered into as a result of cross-border mediation. And at the moment, it only covers commercial disputes, so this is really only applicable for international trade. Why is it important? Well, it might lead to similar agreements for enforceability in other jurisdictions who may join up to it, and other areas of law or other types of dispute. And it does provide a level of certainty for the parties to a mediation. It's going to be easier and cheaper to enforce a settlement agreement if another country recognizes it, because it's going to simplify your litigation. You only have to prove that you entered into a settlement agreement. You don't have to start your whole case again in the country that you want to enforce in. There are exceptions. It doesn't apply to settlement agreements that are already enforceable as a judgment or an arbitration award, and it doesn't apply, as we've seen, to settlement agreements concluded for personal, family, household purposes, such as where one party is a consumer. And it doesn't apply to family inheritance or employment law. The courts can refuse to grant relief on certain grounds, and they are to do with things like incapacity, if the agreement itself is defective, so it might be not binding for some reason, or if it's contrary to the public policy of the contracting party. I take that to mean where the contracting party is a government itself. It came into force on the 20th of September. 53 countries have signed up to it, including United States and China, India, South Korea. Some countries have signed up to it, but with exceptions, so that their governments themselves aren't included. So Belarus, Iran, and Saudi Arabia have said they'll sign up to it, but their governments don't want to be bound by it. The UK hasn't ratified it. The question is, will it become a signatory to it? That question is well above my pay grade, so I'm going to direct you to Jonathan's talk on Thursday at 10. So what's the vision for the future? What might it look like, say, in 5 years' time? I'm going to have a guess. You don't have to agree with me. Please feel free to shoot any of this down. It's just me looking into a crystal ball and throwing this out there. I mean, at the moment, the eyes of the mediation world are focused on whether mediation should be a profession, a formal profession. And we've got another talk on that by a very experienced mediator, Stephen Walker, on Friday at 2 o'clock. And the question is, you know, should we move towards that? It does seem to be the way we're going, and it seems right that we should be doing that to get complete credibility. What we could have is something looking like the points on the slide. So, you know, an international regulatory body overseeing training, development and standards. You might have global harmonization on how it's delivered, community engagement, a global charter for the use and promotion of mediation for businesses, community and non-profitable organizations. And then perhaps we'd want a central hub with high quality and trusted resources and information for the general public to access. Like on International Mediation Awareness Week.org. Sorry for the shameless plug. I think we need to say something about COVID and how that's going to affect the landscape. I mean, it's been predicted that as a result of many legal issues thrown up by the pandemic, for example, in the UK, you can think of all the contractual issues that are going to arise as frustration, force majeure, breach of contract, big impact on landlord and tenant law and insolvency. And you could conceive that we might have an avalanche of cases coming and the courts won't be able to cope, or they're going to have to deal with it in a certain way. We could see a move towards more remote mediation, or perhaps a balance of that and in-person methods. Perhaps we could see more early intervention by the courts so that cases suitable for mediation don't clog the courts up. And it could perhaps become almost, if not actually, compulsory in all civil cases before you bring or continue court proceedings. The courts are already doing early neutral evaluation, and you know, one thing we could have is a movement away from traditional court litigation altogether and towards some sort of hybrid model of mediation, early neutral evaluation, arbitration, adjudication, for, you know, a sort of bespoke model for whatever suits the dispute before the court. And I think as the public become more aware of mediation and its benefits, mediators may become the first port of call over lawyers, maybe. I'm already seeing this in low value disputes. So if you try and issue a claim on MCOL in the UK, the money claim online, you can issue a claim in the county court online. I think it's up to 50,000. You get the website giving you a list of mediators before you issue your claim, not a list of lawyers. So I'm certainly getting inquiries from unrepresented parties and then doing mediations for them without lawyers, which is difficult. Okay, so just to wrap up then, I think hopefully it's been very quick, but I've gone over where we are now, how did we get here, what's happening globally. We've seen some current developments, some will be necessary or as a result of necessity, some not, and then hopefully, you know, just a few pointers as to what I think the direction we might be going in. Thank you for listening. It was a pleasure to share that with you.